Well, thank you very much, everyone, for coming to see this session today. Thank you very much, Indri, for the invite to this conference. It's been fantastic to come here. I feel I've learned so much already from all the speakers that we heard this morning, and it's just really nice to get a chance to come and contribute in a small way to what I think has been an excellent conference so far, and visit Lithuania for the first time in Vilnius, which I've never been to before, and hope to spend a bit of time tomorrow visiting some of the sites in the Old Town. So, although as many of you can probably tell from my accent, I am Scottish, I'm going to speak about the English jurisdiction today. I work in England at Newcastle, although I was born and bred and still live in Scotland. And Scotland and England are quite separate and distinct jurisdictions, legally speaking. And when it comes to mediation, again, there are quite significant differences. So I'm talking about the English system today, and some of the ways in which parties have been incentivized or perhaps pressured sometimes or cajoled into entering into the mediation process in different ways. And essentially there are two ways in which this can be done, either by issuing carrots, so incentives of different ways to try and get parties to mediate, or by hitting them with sticks if they fail to do so, by punishing them for not mediating or forcing them into the mediation arena. And in England, certainly, we're shifting from the former to the latter. We're moving more towards the stick than the carrots, and many people may feel that's not perhaps the right way of doing things. So more specifically, what I'll talk about today is the English journey towards the promotion, embedding of mediation, particularly within its civil justice, its court system. And that's been very pronounced in the last 2 or 3 decades. I'll look at the different ways in which parties are pressured or incentivized into mediation in England through both carrots and sticks. I want to talk about the move to compulsion because, in a sense, there's a feeling that incentivizing parties to mediate in different ways just has not gone far enough and has failed to bring sufficient numbers over into mediation, and that compulsion or pressure has become necessary to do so. That is I think, the dominant narrative, in the mediation civil justice sphere in England right now. I'll talk about some of the manifestations of those mandatory policies briefly, and then talk about some of the policy issues we need to think about in taking a balanced approach to encouraging the use of mediation in England ahead. So that's essentially what I'll talk about in the timer says 12 minutes, so it will be 12 minutes. So the journey towards promoting mediation, I'll take the first issue and the third together. Although mediation's been around in England since the late 1970s when the first developments occurred in the family field, I think we tend to view the most significant developments in general civil commercial cases arising from the Woolf Review reforms of civil justice. In the late 1990s, Lord Woolf produced 2 reports, Access to Justice reports, which fundamentally reformed the civil justice system in England, and from that developed the promotion of mediation within the courts itself. And it brought forth what's very important and is now found in the civil procedure rules, which came into force in 1999. They were passed the year before, what's called the overriding objective. And this idea that it's the mission of the courts to deal with cases justly, of course, as we might expect, but also proportionately. This idea that civil justice is a limited resource and must be rationed, and the amount of resources devoted to one case must be proportionate to the needs of the parties concerned. That could be the value of the dispute, for example, and also the potential for settling the case instead of going to court. And from that, we can very much say that settling the case has become a primary goal of the English civil court system through case management, where judges much more closely control cases, direct parties to different phases, try to encourage the parties to narrow the issues, resolve matters, settle the case. And a real drive to settlement manifests in many different ways in the English system, both pre-action, I'll say a bit more about pre-action protocols, effectively steps you must take prior to initiating the court action, and also within the court itself. And one thing that's occurred quite significantly are judges on the bench significantly promoting mediation, but also off the bench in England, expounding the virtues of the process. Many eminent judges have spoken very much in favour of settling cases through mediation. So moving on to the pressure and incentives to mediate, we haven't had compulsion in England, at least formally speaking, unlike some other jurisdictions. We are moving towards it now, as I'll say at the end of this presentation. Lord Woolf was very enthusiastic about mediation in his Access to Justice report, but he stopped short of saying that parties should be compelled to mediate, but rather we should resort to encouragement of the parties in different ways, court encouragement. Nonetheless, after the Woolf reports, a couple of early decisions, the courts decided that they did have the jurisdiction to compel parties to mediate, parties who didn't want to mediate the case, but that was stopped short in a very important case that I'm sure most of you will have heard of, Halsey, the Halsey decision, in which Lord Dyson, as he was then, said that to compel parties to mediate would be an unacceptable obstruction to justice under Article 6 of the European Convention of Human Rights. And although that statement was technically obiter and has been significantly doubted since as a general proposition, nonetheless it had a significant impact on the promotion of mediation in England at that time. And after that, compulsion just did not occur in the formal sense. But nonetheless, in England, we have many other incentives or pressure points for parties to settle cases through mediation. I'll run through some of them for you. I think probably the most controversial area and very well developed in England are these cost sanctions that judges will impose on parties in, let's say, commercial actions, where a party has refused to mediate, and the offer may have come from the judge or from the other party, but the court deems that refusal to be unreasonable. Based on a range of factors, had the relationship broken down between the parties? Had the parties already attempted to settle the case? Did a party have a reasonable belief in the veracity of their own case, the strength of their own case, and some other factors as well? And by looking at those factors, was the decision to mediate or not mediate, as the case may be, reasonable in the circumstances? And many parties have fallen foul of this. So even if you win the case, and you could say we were vindicated, we were right not to settle and negotiate our rights away because we won today, nonetheless, the court can still punish you in cost orders, so effectively reversing the normal cost-reward system where the loser pays the winner's costs. That can be reversed on the basis that you unreasonably refused to mediate. So mediation is not compulsory as such, but nonetheless, if you fail to do so and the court believes you should have, you're going to be punished quite significantly. So that's a significant pressure. In family matters, and this is really echoing something that Giuseppe was talking about this morning. Let me just go back. Too long in that slide, obviously, for the system here. We do have and have had for many years what are called MIAMs, so compulsory mediation, information, and assessment meetings, where parties in divorce cases, for example, in England, they don't have to attend a mediation as such, but they must attend a first information session with the mediator to find out about the possibility of mediating and where the mediator can assess the case for suitability for mediation. So that's been around for quite some time. And what's interesting about MIAMs is that they're not very effective in England actually at the moment. And that's not because of the MIAM itself. It's because of the way in which they are governed, I think. It seems to be the case that many parties are able to avoid this obligation when nonetheless they should have undertaken one prior to going to court. The courts don't seem to govern the jurisdiction very well or scrutinize parties' reasons for not attending. There are exceptions, for example, domestic violence cases, some other exceptions. But we also know that when parties do attend a MIAM, in 75% of cases, they do proceed to mediation. So the concept does potentially work. We also have currently in England for small claims, so matters below £10,000, we have a free mediation program. It's voluntary. It's really opt-in rather than opt-out. But again, take-up is very low. 21% of parties only, the research tells us, are proceeding on to mediation. Settlement rates are reasonable, above 50%, but very few are going through. There is legal aid availability for mediation in some actions, and also in the family field as an incentive, there is a £500 voucher scheme in which parties can pay for the costs of family mediation. That's been actually very successful and quite significant success rates in terms of parties mediating. It's above 65% parties have mediated through that scheme. So despite all those very good things, I'm going to do this quite quickly, why have we moved on to compulsion? There are a number of reasons that I'll set out here why it's just not been enough so far. Efficiency reasons are to the fore. The state primarily sees mediation as a way of saving money, judicial time, costs in the administration of justice, and it believes that not enough money has been saved with the purely voluntary mediation or pressure to mediation that we have. And one of the issues around cost sanctions for unreasonable refusals has been that the regime's been attacked a lot by commentators on the basis that it's wholly unsatisfactory, the cases are not consistent, parties have no idea whether or not in advance their refusal to mediate would be deemed to be unreasonable because the cases are very inconsistent, depends on the judge you have on the day to what extent they are sympathetic or otherwise to mediation. And I've also seen a shift in thinking from mediators. I think even 10 years ago, if you spoke to general mediators in the UK, most would be against mandatory mediation. But quite a number now, it seems, and certainly mediation bodies, such as the Civil Mediation Council, bodies such as CEDAR, have come out in favour of mandatory mediation. And obviously Halsey, as I've said before, has been attacked as simply wrong, and an unfortunate decision having such a significant influence. So the last thing I want to talk about, really, and I'll save the last slide for our discussion perhaps, is just what's happening now in England. The situation is moving incredibly rapidly on different fronts towards potentially mandatory mediation. From April next year, we will have, it seems, mandatory small claims mediation impacting pretty much all cases below £10,000. This will be a 1-hour telephone mediation, free of charge, provided by in-house mediators, and Graham was talking a bit about that this morning. The MOJ, earlier on this year, proposed to bring in mandatory family mediation, gone to amber now. It's warning me that my time is getting slow. I like the traffic light system they have here. And that it wouldn't be enough to attend a MIAM, but also attend a mediation that would become mandatory. Family mediators I've spoken to are not particularly keen on that, and that has gone quiet. I don't know if that's actually going to happen. We also have proposals in the areas of special educational needs, where mediation is very well embedded in the UK, for those to become mandatory as well. And there's also proposals to reform pre-action protocols, so the first step before entering the court process, calling for compulsory settlement negotiations. Not mediation necessarily, but to show that you have attempted some kind of settlement negotiations. And the final thing on here is that the Halsey decision is currently being scrutinized as part of our current English case, Churchill, and we expect a ruling very soon, and that's likely, I think, to say that Halsey was probably wrong in its determination. I won't do the last slide, which is just about future policy issues, but these are things we need to discuss in charting the way forward. Regulation, quality control, the need for greater education at all levels, how to address the justice gap when we're compelling parties to mediate without legal advice and assistance, and the dangers of efficiency drivers, essentially, promoting mediation for the wrong reasons potentially, coming up with models that are not well funded and provide a poor service. So thank you very much, everyone. Great to be part of this. Thank you very much.